All rise. Third Circuit Court, the County of Wayne is back in session. The Honorable David Groner presiding. Please remain quiet and be seated.
Calling case 08-10496, people versus Kwame. Today is the day for a decision on the restitution hearing.
Good afternoon, Your Honor. May it please the court, I'm Mr. Ringus on behalf of the people.
Good afternoon, Your Honor. Robert Spada, appearing on behalf of the people.
Michael Allen Schwartz on behalf of defendant Kirkpatrick, who is present here in court today.
Good afternoon, Judge Dan Heiser, appearing on behalf of Mr. Kirkpatrick.
And also, Your Honor, I would let you know we have present here today Willie Gary, who's an attorney who's counsel today.
Okay, Mr. Gary, your reputation precedes you. It's an honor and a pleasure to have you. I didn't know you were going to be here. Have you filed an appearance in this case?
Not in this case, Your Honor.
Okay. All right, then I'm going to ask that you sit not at counsel table. Unless you have an appearance, you're not allowed to sit at counsel table. Okay. That's fine. And I take it that you represent Mr. Kirkpatrick in different matters.
Yes, sir.
Thank you.
Yes, sir.
Thank you. All right, the court is ready to rule on people's motion to modify defendant's probation and restitution. The people argue that the defendant violated his sentence agreement in terms of probation because he did not forfeit his tax refunds. He did not assign his pension dollars, and he took funds from the Kilpatrick Civic Fund for his personal benefit. The defendant's restitution should be modified because the defendant failed to disclose all his assets. The loans from the four corporate lenders is fungible money and equals an asset, but will probably never be paid back. That is a gift. The defendant responds. The defendant is paying his restitution per the court order, 30% of his income. That the defendant has 5 years to pay off his restitution. That the loan does not equal an asset or income. This court is satisfied that the motion filed by the people does not request incarceration for the defendant, that the people want the restitution. This court is satisfied that the people's motion is not to set restitution, but to modify the terms of the restitution payments and probation. Mr. Schwartz inaccurately cited the law that this court must be satisfied by a preponderance of the evidence regarding the restitution. That would be true if this court had to make a determination as to the restitution amount, but that amount is agreed upon by all the parties. Let everyone remember that the City of Detroit, the defendant, and the prosecutors all agreed to $1 million in restitution. I only agreed to the $1 million because the city agreed to that amount, despite the city's underlying loss of $8.4 million. It is this court's legal mandate to collect those dollars, that being $1 million, to the City of Detroit. This court previously made a monthly restitution determination as to the defendant's ability to pay restitution, and that was in March of 2009. As indicated in my order, that was based upon defendant's known assets and income, 30% shall go to restitution, including any gifts to defendant or his family. I was not indifferent to defendant's obligation to support his family, believing defendant and his family could initially live on $14,000 gross income per month. Had I known that defendant had received large sums of money in those first months after being released from jail, I surely would have ordered that all defendant's income, annuities, etc. be immediately paid for restitution. That is my constitutional mandate. This court, having reviewed the bank records subpoenaed, hereby grants in part and denies in part people's motion to modify restitution and probation. For the record, the defendant agreed to 5 years probation. The defendant agreed to pay restitution of $1 million. The defendant is wrong when he argues that he has 5 years to pay his restitution. All the lawyers know that the restitution is always paid up front based on ability to pay. This court is satisfied that the defendant could have paid significantly more than the $6,000 per month that I ordered at the time of setting the restitution payments. This court is satisfied that the defendant violated his sentence agreement with the people by failing to forfeit his tax refund dollars and failing to assign his pension to the City of Detroit. This court is satisfied that the defendant violated this court's order by accepting funds from the Kilpatrick Civic Fund for his personal benefit. This court is also satisfied that not only did defendant misrepresent his ability to pay restitution, he lied in his March 24th, 2009 affidavit, and that he could only afford $6 per month for restitution. Pursuant to his bank statement ending April 15, 2009, defendant's joint account with his wife showed deposits of over $100,000 in March of 2009. This court wonders if the public would have ever been put on notice of the enormous financial windfall if defendant had not asked for a reduction of restitution to $6 per month. At the same time, he moved into a mansion. Further, this court is satisfied that defendant intentionally failed to comply with this court's disclosure orders and thereafter moved funds to his wife's account in an effort to avoid paying restitution to the city of Detroit. We need to remember why we are here. It is not a crime to live like the privileged, but we are here because you committed perjury. You pled guilty and you agreed to pay $1 million in restitution, but you have not been responsible in paying it. You testified that you borrowed from friends, and there is evidence on this record that you made partial payments at times. In fact, you couldn't even remember who made some payments for you. You have not been credible in this courtroom, and you again have not been honest to the city of Detroit.